And so, Paul, let's just start with the basics, and that is people are moving, they're mobile these days, and if somebody comes to Florida, at what point in time are they going to be able to use the Florida courts to seek a divorce?
The jurisdictional requirement is to have been a resident of the state of Florida for the 6 months immediately prior to the filing of the petition for dissolution of marriage.
And so if you were a married man and let's say you lived in Ohio with your wife and children, and you're a married man and you moved to Florida, 6 months later you're telling me that he could use the Florida courts to get a divorce.
Well, that would depend on a number of factors, but technically the court could have personal jurisdiction over him and still lack subject matter jurisdiction over the Ohio case if mother and children are still living in Ohio.
So the Florida court is not going to be able to determine child support or child visitation since the kids live in Ohio. I'm making up the story, of course.
Yes, that would be the case. There's a difference between subject matter jurisdiction and personal jurisdiction, and subject matter jurisdiction can never be waived.
So the Florida court might very well say, hey, you're divorced, but that's as far as I'm going with you.
Well, the marriage was last viable in Ohio, so I would recommend that Florida new resident retain Ohio counsel in order to take care of that.
Okay. So realistically, this divorce should be happening back in Ohio. But let's take something more